I've got some amazing breaking news to share with you from the Katie Phang News Channel. A federal judge in the Middle District of Georgia, Columbus Division, has entered a 22-page order dated June 3rd, 2025. And I needed to share it with you guys because when you read it, you will understand why it is good news. It is the third of judicial orders wherein discovery has been allowed to proceed against the Trump administration and its agencies that are facilitating the Trump administration's illegal and unconstitutional kidnapping and deportation of people off of United States soil. In this particular case, in the Middle District of Georgia, a man by the name of EDQC, or more accurately, his initials, EDQC, he was just summarily sent to CCOT down in El Salvador, that horrific prison down in El Salvador. Back on February 10th of 2025, he filed a pro se petition for a writ of habeas corpus. We've talked about habeas corpus here at the Katie Phang News Channel. It is a constitutional right that is afforded to all people. It does not make a distinction as to whether or not you are a United States citizen or not. When he filed this pro se, people, that means that he filed it on his own behalf. He didn't have a lawyer, but he said, I am going to fight my wrongful detention. He ended up getting pro bono counsel appointed for him by the court. And according to the amended petition for writ of habeas corpus, this man was transported to El Salvador on March 15th, 2025, and immediately placed in CCOT, the Centro de Confinamiento del Terrorismo, the Terrorism Confinement Center in Tecoluca, El Salvador, quote, at the request and the expense of respondents, the respondents being the Trump administration, et cetera, and other defendants. In his prayer for relief, remember we talked about this yesterday in the lawsuit brought by Ras Baraka, Newark mayor, against Alina Habba and Ricky Patel. The prayer for relief is at the end of the document wherein the claimant, the petitioner, the plaintiff is asking for certain remedies from the court. In his prayer for relief, EDQC is asking for, quote, that the court order respondents to immediately release him from their custody and facilitate and effectuate his prompt return and release into the United States, or to facilitate and effectuate his prompt removal and release to Venezuela. This is important. He's Venezuelan. He ain't freaking El Salvadorian. So anyway, on May 5th as well, he moved for what we call expedited jurisdictional discovery to address whether he is no longer in the custody of the United States government and whether the court can provide meaningful relief on his petition for writ of habeas corpus. Let's take 1 second to break this down. Expedited jurisdictional discovery means the following. Expedited, on a faster basis than normally would proceed otherwise in the course of a regular case. Jurisdictional discovery means the ability for a party to be able to explore whether or not jurisdiction exists for the court to be able to exercise its power or its orders can have any type of teeth for a certain case, for certain parties, etc. In this instance, the idea that the United States government is saying, well, we don't have jurisdiction over him, so it becomes irrelevant. The court's saying, no, I actually disagree with you at this time, and I'm going to allow discovery to proceed so that EDQC can present his evidence to the court as to whether or not the court could still have the ability to bring this man back from El Salvador to the United States. Now, this is a 22-page order, and actually it's a very straightforward read, but I want to make sure that this is clear. EDQC alleges he's never even been to El Salvador, folks. He has no connection to the country other than that's where the United States decided to send him. The federal judge in this case, she says the following. An alien must be given notice prior to removal to a third country and the opportunity to seek withholding of removal under the Convention Against Torture and another federal statute. That is exactly what the United States Supreme Court has said is allowed to happen and is required to happen. That is due process, people. According to EDQC, he received no notice and no opportunity. The judge says if that is true, then his transfer and placement in CCOT was likely unlawful. Okay, now let's talk about the discovery that this judge is allowing to happen in this case. So it's interesting. The judge actually tells the federal government that, look, You may argue that because EDQC has been removed from the United States, from its soil to a third country, so there are no circumstances absent absolute control by the United States over that detention site that could require the court to have to force him to be returned, right? In other words, the government is saying, we don't have him in United States custody because he's currently a CCOT. So they're throwing their hands up in the air and saying, don't look at us, judge, because we're not going to be able to bring him back and we're not able to do anything. But more importantly, judge, you can't do anything about it because he's not in U.S. custody anymore. But the judge says this: the court does not agree that custody is so limited in the context of this case. Instead, the court agrees with the United States District Court for the District of Columbia that the detention of aliens, such as EDQC, at CCOT potentially implicates the concept of constructive custody. And who is she citing to? Judge James Boasberg, chief judge in the district court in D.C. You know, the guy who had all of those planes take off, and the U.S. government said, oh, sorry, judge, they already took off. We don't have custody of them anymore. That great judge. This judge continues to say, constructive custody exists whenever the imprisoning sovereign is the respondent's agent. The prisoner's liberty is restrained by the respondent's parole conditions, or the prisoner can point to some continuing collateral disability, which is the result of the respondent's action. Okay, that's a lot of legal, but the first part's really important. The imprisoning sovereign, that means El Salvador. Is El Salvador the United States government's agent? Ooh, and this is where it gets good, people. I'm going to start on page 9 of this 22-page order. Here we go. EDQC, this man who was wrongfully stolen from the United States and put in El Salvador. According to the court, he alleges sufficient facts to warrant discovery on the issue of whether he is within the constructive custody of the United States. For example, he claims the following. The United States is paying El Salvador $6 million to detain aliens such as him, and that the term of that agreement for such detention is 1 year, pending the United States decision on the long-term disposition. He is quoting the government, by the way. Secretary of State Marco Rubio, who's one of the defendants in this case that he's suing, also says that the detention of these aliens would save our taxpayer dollars. Respondent Kristi Noem, the Secretary of the Department of Homeland Security, she's also being sued in this case. She said during a tour of CCOT that the facility is one of the tools in our toolkit that we will use if you commit crimes against the American people. EDQC then goes on to cite the president of El Salvador, who confirmed that El Salvador is, quote, offered the United States of America the opportunity to outsource part of its prison system. Then there's the statement made by the vice president of El Salvador. El Salvador was holding Kilmar Abrego Garcia. We haven't forgotten about you. We have not. Kilmar Abrego Garcia. He's being held at CCOT, according to the vice president of El Salvador, because, quote, the Trump administration is paying El Salvador, the government of El Salvador, to keep him there. This is fantastic. EDQC then alleges that the El Salvadoran vice president has offered to hold inmates of other countries, and that the status of inmates or the person arriving isn't determined by El Salvador. It's determined by the state that requests the service that's being provided by El Salvador. Additionally, when asked whether the United States could get Mr. Kilmar Abrego Garcia back from El Salvador, President Donald Trump responded, quote, I could. So then the court says, the court agrees with the D.C. District Court that these allegations are sufficient to warrant discovery on the issue of custody. You know why this is so delicious, people? These dumb bunnies keep on opening their mouths and saying stuff. And because it's true, interestingly, right? We are paying El Salvador to keep these people in CCOT, and we do have the ability to get them back. EDQC is using their own words against them. It is chef's kiss to be able to do this. Now let's talk about what discovery is going to be allowed, meaning what did the judge say is going to have to happen in this case? Well, apparently this is what's going to happen. And I'm going to move quickly through this. And I invite you to look at this order, and I'll post it for you guys to see. But in this order, and here's where it gets good. Documents directly related to the terms of any agreement between the United States and El Salvador to accept and detain non-U.S. citizens transferred from the U.S. to El Salvador. This court says this is relevant and proportional to the needs of this case, so that has to be turned over. What else has to be turned over? The court is ordering the United States government, for all documents relating to EDQC's transport or removal from the U.S. to El Salvador and to CCOT, including flight manifests. Documents relating to his confinement from February 10th to the present, including documents specifying his location of confinement, his conditions of confinement, the legal basis for his confinement, his anticipated length of confinement at CCOT, and his custodial status. Any documents provided to him within 72 hours prior to or within 72 hours after he was transported or removed to El Salvador. Here we go. All communications to or from anyone in the government of El Salvador are connected with CCOT concerning this man. In addition to the documents, depositions are going to happen. Sworn depositions under oath are going to be taken from a representative of the executive branch who has to provide information that is authorized by this court order, including the following: a description with particularity of the terms of any agreement, arrangement, or understanding between the governments of the United States and El Salvador to confine in El Salvador non-U.S. citizens that are sent from the U.S. or transported from the U.S. to El Salvador, and a list of each payment that has been or will be made or withheld in connection with the detention in El Salvador of EDQC and other non-U.S. citizens, that includes Kilmar Abrego Garcia, sent from the U.S. to El Salvador, including when these payments were made, the amount, by whom, and to whom. Now listen, this is interesting. The court said, look, I'm going to limit this information about the payments made to just EDQC. However, he still gets his info if the payment was made in a lump sum and it also covered other non-citizens. Again, could cover and probably will cover Kilmar Abrego Garcia. The court also is allowing these depositions. They will not exceed 7 hours, but they are going to be of DHS ICE and the State Department regarding those agreements, the agency's knowledge of facts relating to EDQC being in El Salvador, these types of agency policies and procedures relating to the detention of non-U.S. citizens in Salvadoran prisons, the agency's decisions to send these people to El Salvador, and the agency policies and procedures relating to the identification of non-U.S. citizens for the purpose of these third country removals to Salvadoran prisons. And there's like a briefing schedule, and this all has to happen very quickly, right? So remember we talked about it being expedited discovery? Within 24 hours, these discovery requests will be served on the U.S. government. Within a week of that, they're going to give their responses, and depots will be done within 2 weeks of service of notice of those depots, etc. I mean, this is powerful stuff. Dated June 3rd, 2025, United States Magistrate Judge Amelia G. Helmick. Let's take a second here and let's talk about MAG judges. A magistrate judge is a judge that is assigned to a district court judge. And I hate that maybe I'm trying to say that a MAG judge is below a district court judge. And I guess maybe in a hierarchy they are. But a magistrate judge's ruling has just as much import as a federal district court judge's ruling does have, right? Now, you can challenge the findings that are made by a magistrate judge in federal court, but in this instance, I would be stunned if this order is overturned in part or in whole by the district court judge to whom this magistrate judge is assigned. And if you guys want more info about even just the hierarchical structure, kind of like the nuts and bolts in federal court, let me know and we can talk about it. But what's really good about this is that the United States government is having its feet held to the fire when it comes to the illegal kidnapping and deportation of people. And I'm not even going to make a distinction between the U.S. citizens and non-U.S. citizens, although obviously if it's a U.S. citizen, I think it is more egregious. And yet sometimes I don't, because you know what? Due process doesn't make that distinction, folks. It doesn't make that distinction. Due process in the United States Constitution does not identify U.S. citizens as being special people when it comes to due process, when it comes to these immigration procedures. And very quickly, before you and I part ways, I'm just going to share some information with you, which is the following. There's a fantastic Texas Tribune article that I invite you to read, wherein it is revealed that the Trump administration knew that the vast majority of the 238 Venezuelan immigrants that were sent to CCOT in mid-March were not convicted of crimes in the U.S., although the U.S. wanted to label them as being terrorists before they were deported. The government's own data showed that U.S. officials knew that only 32 of those 238 deportees had ever been convicted of a U.S. crime, and that most of those were for nonviolent offenses, such as retail theft, that's also known as shoplifting, or traffic violations. In addition, ProPublica and the Texas Tribune, with Venezuelan media outlets, obtained lists of alleged gang members kept by Venezuelan law enforcement officials and Interpol. Those lists include some 1,400 names. None of those 1,400 names included those 238 Venezuelan deportees that were sent to CICOT, that horrific prison in El Salvador. People, people, people. When I tell you to celebrate the wins where we get them, this is what I mean. I know it is hard to keep your optimism up in the face of such cruelty and horror that we see. But the rule of law still stands. We have judges across the board, some of whom are Trump appointees, that are saying not on my watch, and that the law requires due process, and the law is also requiring expedited jurisdictional discovery that's going to give more information about this backroom deal, apparently between El Salvador and the United States. Be mad, be outraged, demand accountability. We'll have more information on this coming soon. Katie Phang here. The truth matters now more than ever. So hit that subscribe button so you don't miss a thing. Thanks for watching.